Today we are going to learn a very important topic, fundamental right. So fundamental right did not come suddenly with the constitution. Their development was influenced by both international development and India's freedom struggle. So first Magna Carta of 1215 in England introduced the important principle that even the ruler must follow the law. And coming to India, in 1928 the Nehru report recommended a list of fundamental rights for Indians. Then in 1931, the Karachi resolution of the Indian National Congress emphasized important rights such as civil liberties, equality, freedom of religion and protection of minorities. Finally, when the Constitution of India came into force on 26 Jan 1950, the fundamental rights were incorporated into Part-3 covering Article 12 to 35. So this is how the idea of fundamental right gradually developed and finally became an important part of the Constitution. Let's look at the Article 12. So it defines the term state for the purpose of fundamental right. State includes central government and parliament, state government and state legislature. Local authority include municipality and panchayat, and authority within the territory of India and authorities under the control of the government of India. For example, if a government authority take an action that violates your fundamental right, you can challenge that action before the court. Suppose a government department refuses to give someone a government benefit only because of their religion. The government department comes under state under Article 12. So the person can challenge the action as a violation of fundamental right. Let's talk about Article 13. If Parliament make a law that violates a fundamental right, the Supreme Court can declare that law unconstitutional to the extent of the violation. It means Article 13 says that any law which is against fundamental right is not valid. It basically says that fundamental rights are more powerful than ordinary law. First, there are laws made before the Constitution came into force which are against fundamental right will be invalid to the extent of that conflict. And second, after the Constitution came into force, the state cannot make any law which takes away or reduce fundamental right. And if the state makes such a law, it will be invalid to the extent of that violation. Article 13 is also an important basis for judicial review, which means court can examine law and declare that invalid if they violate fundamental right. Now let's talk about right to equality. So right to equality is covered under Article 14 to 18 of Part 3 of the Constitution. It is basically ensure that people are treated equally before the law and protect them from unfair discrimination. Article 14 provides two things. First, equality before law. It means that no person is above the law and everyone is subject to the same law. And second, equal protection of law, and it means that people who are in similar situation should be treated equally. However, equality does not always mean treating everyone exactly the same. The law can make a reasonable difference between people who are in different situations. For example, suppose a government provides special facility for persons with disabilities. So this does not violate equality because people with disability may require additional support to achieve equal opportunity. If we talk about Article 15, so Article 15 protects citizens against discrimination by the state on certain ground. Because of that, the state cannot discriminate against a citizen only on the ground of religion, race, caste, place of birth, etc. For example, a person cannot be denied access to a public place merely because of their caste or religion. But is every difference in treatment prohibited? No. The Constitution allows the state to make special provision for certain groups, such as women and children, socially and educationally backward classes, scheduled tribe and economically weaker section. So these special provisions are intended to promote real equality and equal opportunity.